So let us start with constitutional developments. Constitutional developments. We can write down East India Company occupied Bengal province after the Battle of Plassey. Initially, it was a trading company. But suddenly they found themselves. Initially, it was a trading company, but suddenly they found themselves in ruling a vast territory, a vast real estate territory of Bengal province. As they did not have any experience of ruling a territory previously, they had come out with many changes and innovations. They had come out with many changes and innovations over a period of time. To improve governance. From 1858 onwards, the entire administration of the country went into the hands of the British Parliament. Between 1773 and 1947, many changes were introduced. In the governing systems, which later had become the basis of our constitution. Next paragraph. From 1773 onwards, from 1773 onwards, British Parliament passed legislations, legislations regularly after a period of 20 years. Period of 20 years till 1853. The objective of all these legislations, the objective of all these regulating acts, the objective of all these regulating acts is to control activities of East India Company, control activities of East India Company. (1853) Regulating Act, 1853 Regulating Act is very significant. It is very significant from the point of view of constitutional governance in India. Constitutional governance in India, from the point of view of constitutional governance in India. It has for the first time, introduced the separation of powers. Separation of powers. For the first time introduced separation of powers. It has laid foundations. It has laid foundations for what is popularly known as parliamentary democracy. What is popularly known as parliamentary democracy. It has separated the functions of executive from legislature. It has separated functions of executive from legislature. Executive was made responsible for policy implementation, whereas legislature was given the responsibility of law making, law making. It was not implemented as East India Company faced revolt. As East India Company faced revolt from local princes. Next paragraph. Local princes. After 1857 War of Independence, East India Company's rule had come to an end. East India Company's rule had come to an end and was replaced with British Parliament. From 1858 onwards, British Parliament passed many legislations. PASSED passed many legislations which ultimately culminated in 1947 Indian Independence Act. Indian Independence Act. Next paragraph. Modern concept of rule of law. Modern concept of rule of law. Modern concept of rule of law for the first time was introduced in Indian administration during the period of 1860s. During the decade of 1860s. IPC, Indian Penal Code, 1860. CRPC, Criminal Procedure Code. CRPC, Criminal Procedure Code, 1861. Indian Councils Act. Indian Councils Act, 1861. Indian Evidence Act. Indian Evidence Act, 1872. Are some of the legislations which introduced the concept of rule of law in Indian governance. Indian governance. Later, due to demands from Indian nationalists, slowly, 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 constitutional reforms were introduced. Indian Councils Act, 1892. Indian Councils Act, 1892. Introduced representation for Indians. In Central Legislature. in central legislature. Indians were mostly nominated for these positions. Princely states rulers were nominated as members of central legislature. They had the freedom to discuss and debate the legislations, introduced by executive, but they cannot vote. Next, 1909 Minto-Morley reforms. Introduced for the first time elections to the central legislature. It also introduced communal electorate. Indians were given opportunity to contest elections. And become members of legislative assemblies. Next, 1919 Government of India Act. Members of legislative assemblies. 1919 Government of India Act had for the first time gave opportunity for Indians to become part of the executive also. It introduced diarchy in provinces. Diarchy in provinces. The entire business of the government was divided into reserved subjects and transferred subjects. reserved subjects and transferred subjects. In case of transferred subjects, Indian ministers were appointed. Wherein they had the opportunity to take decisions related to the functioning of their ministries. But the final decision will be in the hands of ICS officers. These officers had the power. To veto the decisions of the ministers. Next paragraph. 1935 Government of India Act. 1935 Government of India Act was a landmark legislation. As far as constitutional history is concerned. It had laid foundations for the present day constitution. It abolished diarchy in provinces. It abolished diarchy in provinces and introduced the same at the central level. It was not implemented. Due to Second World War. It also introduced federalism in our polity. Union list and state list. Were introduced. Wherein the powers were divided vertically between the federal government and the provinces A notable feature of a notable NOTABLA feature of 1935 Act, a notable feature of 1935 Act was it introduced a very loose federation. It introduced a very loose federation. It introduced a very loose federation. That is, maximum powers were given to the provinces with the central government taking responsibility for functions like defense, external affairs, communications, money and banking. This act also recommended a central bank for the country. On the lines of Bank of England. Most of the provisions of this act were not implemented. Most of the provisions of this act were not implemented due to stiff opposition, strong opposition from princely states and Indian National Congress. From princely states, due to strong opposition from princely states and Indian National Congress. But it had become the basis of our constitution. So this is what we say about constitutional developments. What we are saying is that if you have to look at the constitutional history of our country, we say that it started with the rule of East India Company. East India Company, after occupying Bengal province in the Battle of Plassey, had introduced so many changes, or you call them as innovations, which had become the basis for our constitution later. From 1773 onwards, the British Parliament regularly passed what is called known as regulating acts, controlling the activities of East India Company. Not only that, within the country also East India Company had introduced so many changes. We cannot say them as reforms. We call them as changes. Why? Because if you look at initially the East India Company from 1773 till 1857, and from 1857 till 1947, the British government, what was their objective? What was their objective? Their objective was to continue the exploitation of the colony. Their objective is what is called economic exploitation. They wanted to exploit the country. And that is the reason why whatever the so-called reforms they had introduced, those reforms were only to ensure that they would be able to maximize the economic exploitation of the country. And as I said that after 1857, in 1885, Indian National Congress was formed, and this Indian National Congress was formed demanding more share in governance, more participation in governance for the Indians. That is the reason why, in order to satisfy the demands of this Indian National Congress, as you know, till Mahatma Gandhi entered into picture, Indian National Congress was dominated by moderates. They were not demanding a complete independence. They were demanding only some kind of a participation for Indians. So the Britishers, they had introduced some cosmetic changes which allowed Indian participation in governance. Again, the objective was basically to satisfy their demands, but not to transfer power to India. That is the reason why, if you look at it from 1885 till 1919, till the entry of Mahatma Gandhi, not many reforms were introduced as such. As you have written, 1853 Act for the first time introduced what we call, it is not parliamentary form of democracy, for the first time they introduced what is called the separation of powers. Because till then in India we had only monarchy, dictatorship. In monarchy or dictatorship, the king or the emperor had absolute powers, legislative, executive as well as judicial powers. It was the Britishers who introduced the modern concept of rule of law in India. Whatever they had in their country, they tried to introduce it, if not completely, partially. So 1853 Act for the first time talked about separating legislature from executive. Please remember, at that point of time there was no legislature at all. There was no legislature at all, because entire thing was controlled by East India Company. And within the country you had the board of directors is there, and outside the country in England you have the court of in India you have court of directors, and in London board of control is there to control the activities of these directors. So obviously, what 1853 Act has done is, it has said that we must separate the functions of legislature from that of executive. Sowing the seeds for what is popularly known as parliamentary democracy. Please remember, whatever we are discussing here, all of them were asked as questions in your prelims. From the constitutional history from 1773 till 1947, every year in your prelims at least 2 to 3 questions will be asked. I don't have to tell you about the importance of every single question in prelims, because most of the students, they clear prelims with 0.33 marks and they will top the examination. If you look at last 4 or 5 years toppers, all of them have cleared prelims with 1 mark or 2 marks. Every single question becomes extremely important. That is the reason why you cannot afford to leave any single question. You must mug up all the provisions of all these acts from 1773 to 1947. What is so special about all those acts? I said the important ones which I have given you here, especially from 1853 onwards. 1853 Act, as you have written, has introduced for the first time this concept of separation of powers. 1853 Act also has recommended what is called examinations to civil services through open competitive examination on the basis of merit. After that, they were implemented. So 1853 legislation was very, very important because it has sown the seeds of what is called parliamentary democracy in India. And then after that, from 1858 onwards, when our entire Indian administration went into the hands of directly the British king or British monarch, it was the British Parliament that started legislating for the entire country. East India Company rule had come to an end after 1857. That is the reason why we say that from 1857 onwards, what the British Parliament had introduced in India was the concept of legal rational authority. From 1857 onwards, they introduced what is called legal rational authority in India through various legislations. The Supreme Court was given the judicial functions. And how did the court function? On the basis of what is called the rule of law. That is the reason why we have IPC, Indian Penal Code. We have the CRPC, Criminal Procedure Code. We have then there's the Indian Evidence Act 1872. All these legislations were introduced. During this period, which basically laid foundations for what is called legal rational authority. Separating the functions of judiciary, and judiciary was expected to perform on the basis of what is called rule of law, on the basis of this IPC, CRPC and everything else. And they introduced, till then, if you look at it, in India, during the Mughal times, the judicial administration was based on Shariat laws, Islam personal laws. And for the first time in India, they introduced the concept of modern concept of rule of law. In fact, some of the reforms that were introduced in India at that point of time, were not even there in United Kingdom also. For example, the civil services which they had introduced, after they were introduced in India, they were implemented in United Kingdom also. Some of the reforms they were introduced. And most of the freedom fighters at that point of time, what did they do? They went to UK. They had seen the functioning of parliamentary democracy there, and they had come back to India and demanded the same for India also. In order to satisfy the demands of those people, as you have written, constitutional governance was introduced. Under 1892 Councils Act, for the first time Indians were nominated to the central legislature. This central legislature, as part of separation of powers, was responsible for law making, with the Governor-General taking the responsibility of implementing the laws. And we have the judiciary that is there to interpret those laws as part of separation of powers or rule of law. And in 1892, as part of the Councils Act, Indians were given representation through nomination. Mostly the leaders of these princely states were given the opportunity to become a part of central legislature. Again, these are all cosmetic measures to satisfy increasing demands of Indians. When they were made the members of central legislature, what they made sure is that they were not given any real powers as such. They could discuss and debate, but they could not vote on the floor of the house. And then 1909 Act further taken this reform and allowed Indians to contest for this central legislature as well as provincial legislatures. And this act also introduced what is called communal electorate for the first time in Indian electoral politics. When we discuss communalism, a very, very important topic which is there in our General Studies paper 1 also, we will talk about all these things. How communalism in India had started. It started with 1909 Minto-Morley reforms. When the communal electorate for the first time was introduced, it has sown the seeds of what we call communalism. Britishers had opted for what is called divide and rule policy. Divide and rule. They divided the Indians on the basis of their religion, on the basis of their caste, on the basis of their region, on the basis of their language, and they ruled the entire country. In fact, when Mahatma Gandhi was asked about the divide and rule of policy of the Britishers, he made a very famous cryptic statement. He said that we divided ourselves and they ruled us. India, that is the problem with Indians. We always divide ourselves in the name of religion, caste, region, language, and we have allowed the foreign powers to rule our country. When I say foreign powers, I am not talking about Sonia Gandhi. Okay? Okay. So, that is what divide and rule policy. And then 1919 Government of India Act, as I said, it had taken these further reforms further and given representation for Indians for the first time in the executive also. First in the legislature, they were nominated, then they were elected, then they were given representation in the executive. Diarchy was introduced in provinces through 1919 Government of India Act. And as part of diarchy, the entire business of the government at the provincial level was divided into what we call transferred subjects and reserved subjects. In case of reserved subjects, the entire decision making process was in the hands of the ICS officers, the secretaries to the department and ministries. Whereas in case of transferred subjects, Indian ministers were given opportunity to head those ministries and departments. But the problem here, the catch here is that even in case of transferred subjects also, in case of a conflict between Indian minister and the British ICS officer, the secretary, can veto the decisions of the Indian ministers. That was the reason why Congress party rejected 1919 Government of India Act. As all of you know, this resulted in the split in the Congress party in the form of pro changes and no changes. No changes were led by Gandhi and Nehru and Patel. Pro changes were Motilal Nehru and others. They said that let us participate in constitutional governance at the provincial level. Let us create a trouble for the British government by joining the government. But finally they also had resigned when they realized the fact that it was a trick played by the British government. Otherwise they did not have any real powers. Then as you know, Simon Commission was appointed. It was boycotted by all political parties in India. Then we had these roundtable conferences, first, second and third. And finally, on the basis of Simon Commission and roundtable conferences, the British Parliament had come out with a comprehensive legislation called 1935 Government of India Act. And what was the essence of 1935 Government of India Act? As we have said, this act introduced various reforms in our constitutional governance. As you have written, it introduced diarchy at the central level by abolishing it at the state level or the provincial level. And it introduced what is called as a federal form of government with union list and state list. Please remember, as part of 1935 Government of Act, there was no concurrent list. It was only union list and state list. There was no concurrent list. The powers of the federal government as well as provinces were clearly divided. What is called vertical division of powers. We had vertical division of powers in the form of the central and the provincial governments. We also had horizontal division of powers in the form of legislature, executive and judiciary, separation of powers. And then 1935 Government of India Act also introduced what is popularly known as a very weak federation, with the central government having control over only very few activities like defense, external affairs and communications and money and banking. That is the reason why it has recommended a central bank for India in the form of Reserve Bank of India, and it has also given more powers to judiciary. It made judiciary more independent also, and it had also provisions for the civil services to ensure the independence of civil servants. Later we say that this 1935 Government of India Act had become the basis of our constitution. After independence, it had become the basis of our constitution. But even this act was not implemented fully. Why 1935 Government of India Act was not implemented fully? Why? Because it faced strong opposition from princely states. We must remember that if you look at Indian political map at that point of time, Britishers directly controlled only around 60% of our country. Remaining 40% of our country was in the hands of the princely states. There was indirect rule by the Britishers of princely states. So that is the reason why the princely states had opposed the provisions of 1935 Government of India Act, because in big princely states like Nizams, they had their own currency, they had their own railways, they had their own railways, they had their own currency, they had their own army also, and they would follow their own independent foreign policies also. So that was the reason why all these major princely states strongly opposed 1935 Government of India Act, and ultimately it could not be implemented also due to Second World War. And that is when of course in 1937 elections were held. Indians had become part of the Central Council of Ministers, but when the British Parliament announced participation of India in the Second World War without consulting the Indian ministers, they resigned, and Mahatma Gandhi started Quit India movement. And you know what happened later. Finally, at the end of the Second World War, Britishers were forced to give India independence, and 1947 Indian Independence Act was the last legislation of the British Parliament. So this is what happened. Now let us come to what happened after we got independence. Let us look at the constitutional history after we got independence. What happened after we got independence? Indian Independence Act 1947. Indian Independence Act 1947 apart from giving complete independence to India, apart from giving complete independence to India, it also created Pakistan. It also created Pakistan on a communal basis. On communal basis. Elections were held to Central Legislature. Elections were held to Central Legislature in 1946. Central Legislature in 1946. That included British India and Pakistan. But members from Muslim League deliberately created hurdles in governance. Deliberately created hurdles in governance. Deliberately created hurdles, HURDLES, in governance, forcing the Congress Party, to accept partition of the country. Partition of the country. To accept partition of the country. Next paragraph. After independence, the central legislature. After independence, the central legislature was converted into constituent assembly. Constituent assembly that was given the responsibility of framing the constitution for the country. Framing the constitution for the country. For almost 3 years, it performed dual functions. DUAL, dual functions. That is, framing the constitution, and performing functions of a legislature. What are the functions of a legislature? To formulate laws, rules and regulations. So, as we are saying here, elections were held in the central legislature in 1946, and Jawaharlal Nehru had become the Prime Minister of the country, with Muslim League as a partner in governance. But the members of Muslim League, they joined the government but not to cooperate with the Congress party, but to create hurdles in governance. Ultimately, the Congress party was forced to accept partition because of increasing violence in the country. And the 1947 Government of India Act, as we have said, it not only gave India independence but also created Pakistan on communal lines. So after independence, we have decided that it has to be the primary duty to come out with a constitution for the country. And that is the reason why the central legislature was converted into this constituent assembly, so that the members would frame the constitution for the entire country. They would frame the constitution for the entire country, and they had come out with a constitution, and it had taken them almost 3 years to frame the constitution. It has taken them almost 3 years. How much time? 2 years, 11 months and 18 days. They had taken almost 3 years, to come out with the constitution. To come out with constitution. So, and during this period, as we say, during this period, the central legislature performed both the functions. One is framing the constitution, and the second one is the regular functions like law making also for the entire country. So then we will have to look at what is this constitution, what are the values that our constitution forefathers cherished, what are the important features of our constitution. You can expect lots of questions from this topic in both your polity governance as well as Indian administration papers. Every year, at least in polity governance and Indian administration, 1 or 2 questions will be asked from these topics only in your mains. For example, the question they would be asking is about 1935 Government of India Act. We say that 1935 Government of India Act is the basis for our constitution. Is it true? Or the question will be that 1853 regulating act has introduced what is called parliamentary form of democracy. The question that 1860s was a decade wherein this legal rational authority was for the first time introduced in our constitutional governance. So let us look at all these things you can take down. It has taken almost 3 years. It has taken almost 3 years for our constitutional forefathers to formulate the Constitution. The basic idea behind a written constitution, WRITTEN, written constitution, was to ensure strict implementation of rule of law. India was ruled by the Britishers. For almost 250 years. During which they denied basic human rights to Indians. Like right to life, right to equality, right against exploitation, right to freedom of speech and expression, and so on. It was decided that the main function of the organs of the state, what are the organs of the state? Legislature, executive and judiciary. Organs of state, legislature, executive and judiciary, is to protect fundamental rights and freedoms of citizens. So if you have to describe our entire constitution in a single line, what we are saying here is that every citizen of our country must enjoy the basic human rights which were denied to them during the 250 years of colonial rule. Every citizen must be able to enjoy the freedom and these basic human rights. What are the basic human rights? Those rights which are necessary for our existence. Basic human rights like right to life, right to equality, right against discrimination and exploitation, right to freedom of speech and expression. These were denied to us by the Britishers. That was the reason why our constitutional forefathers, they had spent a considerable amount of time only on ensuring that every citizen of the country enjoyed all these rights. And that was the reason why they said that the most important function of the three organs of the state, whether it is legislature or executive or judiciary, is only to protect and promote the fundamental rights of the citizens. This is what we call the spirit behind our constitution. Next, let us look at the important values or characteristics or features of our constitution. Important values or characteristics or features of our constitution. What are the important values our constitutional forefathers cherished while framing the constitution of the country? Important values or characteristics or features of our constitution. What are the important values that they cherished? Now, what did they expect? What did they expect from the constitution? What did they think that constitution protect and promote? Let us look at all of them. First and foremost, as we have said, fundamental rights. First, fundamental rights. Fundamental rights. Fundamental rights. Again, as we have mentioned now, entire thing is all about how to protect, or you can say how to restrict fundamental rights. As someone was asked about fundamental rights in our constitution, he said that yes, they are not fundamental rights, they are fundamental restrictions, fundamental limitations. None of these rights are absolute. None of the fundamental rights that we talk about them are absolute. For example, right to freedom of speech and expression. The government can take away your freedom of speech and expression through various legislations. It can take away all your freedoms. Similarly, right to life. Again, most of them are not what is called absolute in nature. That is the reason why they are called fundamental limitations, fundamental restrictions. But our constitution forefathers, they said that the spirit of the entire constitution can be defined in terms of the ability of the organs of the state to protect the fundamental rights of our citizens. As we proceed with our syllabus, whether the government has been able to, whether the organs of the state have been able to perform this function or not. That is what we will see as part of what happened in India since 1947 till now. Very recently, the Supreme Court has mentioned that a right to privacy is also part of our fundamental rights. Right to privacy. That is the reason why Supreme Court has said that Aadhaar cannot be made compulsory for everything. Because if you are making Aadhaar compulsory, obviously you are taking away the right to privacy of individuals. So like this, we will be discussing all those things. Next, what are the other important values our constitutional forefathers cherished? First one, as we have said, is fundamental rights. Second, is the concept of a separation of powers. The concept of separation of powers. Which is the essence of rule of law. Which is the essence of rule of law. Which is the essence of rule of law. The concept of separation of powers. What is the separation of powers? A separation of powers between the three organs of the state, legislature, executive and judiciary. The objective here is to ensure that legislature would not enter into the domain of executive. Executive would not dominate judiciary. Judiciary would not dictate terms to legislature and executive. They are expected to function within their domains with the objective of protecting the fundamental rights of the citizens, with the objective of maximizing welfare of the people. Again, as we proceed, we shall be discussing whether these three organs of the state have performed according to the expectations of the people or not. The third important feature, the value, is federal form of democracy. Federal form of democracy. Federal form of democracy. What do we say? You go back to the ancient times also, right from the ancient times onwards, it was realized that India could not be governed from a single place. During the Mauryan times also, Mauryan Empire was very, very large. But the king or the emperor directly ruled only the capital. The rest of the areas were ruled by the representatives of the king. They had complete independence. And the same thing was realized by the Britishers also. That is the reason why when the Britishers had occupied the country, they had given more freedom to the governors of the provinces. Why? Because India is so vast, and most importantly, there is so much of diversity in our country. There is so much of diversity. You cannot have a single, power center. Why? Because the problems of different regions of the country are completely different. As you can see, in Assam, the problem is floods. In South India, the problem is drought. Can you have the same policy for Assam as well as other parts of the country? Obviously not. So, you must give freedom to the people at the local level to decide their policies depending on their problems. This is possible only when you have what is called federal form of democracy. Almost all the large democracies in the world have only federal form of governments. You take the case of India, it is the case of America. These are all large democracies. I am talking about democracies. We are not talking about China or Russia. They are only dictatorship. They are only dictatorship. All large democracies in the world only have federal form of governments. Take the case of Canada, very large country. Why? Because it is not possible for you to rule the entire country from a single place. Again, while talking about this, if you look at it, as we discussed, the 1935 Government of India Act talked about a very loose federation with the center having minimum powers and with the provinces given maximum freedom. But after independence, we have completely changed it. We have opted for a very strong central government with very less powers for the states. That created conflicts between the center and states all the time. We will be discussing all those things. Next, federal form of democracy after that. Next one is independence of judiciary. This is another important feature of our constitution. Independence of judiciary. Independence of judiciary and judicial review. Judicial review. Independence of judiciary and judicial review. As we keep on saying, if you want your constitution to be fully functional, the most important thing that is required is you need an independent judiciary to interpret, to review the legislations made by legislature and implemented by executive. And judicial independence is the heart and soul of constitution. And what do we say? We say that during the British times, the judiciary was neither independent nor impartial. After independence, as part of the constitution, even in the Government of India Act 1935 also, they talked about independence of judiciary, but it was not fully independent. Why? Because the decisions of the Supreme Court could be overruled by Governor-General or Viceroy. Viceroy or Governor-General had absolute veto powers. By the way, what is the difference between Viceroy and Governor-General? These questions were asked in your prelims. What is the difference between a Viceroy and a Governor-General? What is the difference? Let me test your knowledge of history. What is the difference between a Viceroy and a Governor-General? Any difference? Yes? Yes, there is difference. You always answer difficult questions. Now easy question. What is the difference? What is the difference between a Viceroy and a Governor-General? As I said, at that point of time, during the British times, politically India was divided into British India and princely states. For princely states, he was called the Viceroy, and for British India, he was known as Governor-General. Otherwise, there was no difference. In case of princely states, the designation was Viceroy, and for the territory that was ruled by the Britishers directly, he was known as Governor-General. That is what, after 1857, British Parliament had taken a decision, a conscious decision not to pursue with its aggressive policies of annexation, which ultimately resulted in 1857 War of Independence. That is the reason why they said that let all these princely states be there, let them function independently with Britishers having control over them. The British resident commissioner would be there, he would be looking after all the princely states. Otherwise, the leaders of the princely states were given complete freedom. Everything else would be determined by the Britishers. That is the reason why for princely states, he was given the designation Viceroy to differentiate from the indirect rule and direct rule by the Britishers. Indirect rule by the Britishers in the princely states and direct rule through British India. So coming back here, what we are saying is that when the Britishers introduced the judiciary, it was neither independent nor impartial. After independence, we have opted for a judiciary which is independent as well as impartial, and we also have given a very important function to judiciary, that is to review the constitution, review the laws made by the legislature for their constitutional validity. This is another important value or a feature of our constitution. Next important value or feature of our constitution. Next one is secularism. Secularism. Our constitution for fathers at that point of time itself decided that for India to remain united, to ensure unity and integrity of our country, India should always be a secular country. We should always be secular. As we discuss about this a little bit later, as part of India's history, post-independent India's history, we say that Indian concept of secularism is different from the Western concept of secularism. The Western concept of secularism was based on the idea of ending the dominance of the Christian Catholic Church. That was the reason why in the Western concept of secularism, they talk about complete separation of religion from the state. Religion should not have any kind of dominance or say in the activities of the state. Whereas in India, our concept of secularism is based on our socio-political history of our country. In India, we say that our concept of secularism says that the government recognizes religion, but it does not differentiate people on the basis of their religion. There won't be any discrimination of people on the basis of their religion. But when we say that there won't be any discrimination, there will be positive discrimination to protect the minorities. That is where we have included them as part of our fundamental rights. Article 29, Article 28, 29 and 30, they talk about the cultural and religious freedoms of the people. So this is what we say about secularism. They have realized the fact that India cannot remain united unless we are secular. Why? Because the country was partitioned on communal lines. Again, as I said that we will discuss whether we have been able to continue with our secularism after independence or not. What are the challenges we have faced to secularism? That is when we will be discussing about communalism. Next important feature of our constitution. Next one is, did we talk about parliamentary democracy? Next one is parliamentary democracy. Parliamentary democracy. So again, at the time of independence, we had the choice. We could have opted for either presidential form of democracy that countries like America had, or a parliamentary democracy like United Kingdom. We made a comparison with all the constitutions around the world, and finally it was decided that India would have a parliamentary democracy. Why? Because there were so many reasons which we shall be discussing in detailed manner. One of the important reasons was that India already had the experience of parliamentary democracy with this 1919 Government of India Act as well as 1935 Government of India Act. We never had the experience of a presidential form of democracy. So our constitutional forefathers then decided that it is better to go with a known devil called parliamentary democracy than unknown angel called presidential form of democracy. So this is another important feature of our constitution. Next important feature of our constitution. This was later included also as part of the value, as part of preamble. Socialism. Through which amendment it was introduced? In our preamble. What is the amendment name? 42nd Amendment. 42nd Amendment. So when the discussion took place in the Constituent Assembly, should we include socialism as part of the preamble? That is when Ambedkar has said that every article in our constitution, whether it is directive principles or fundamental rights or anything else, only talk about socialism. Why should we again include that as part of preamble? But later Indira Gandhi, for political reasons, included this socialism. And that is the reason why when we discuss Representation of People's Act, what we say is that in this Representation of People's Act 1951, election commission has the authority to derecognize a political party if it does not commit itself to the ideals of socialism. Election commission can derecognize a political party. What is this socialism? Nobody knows. But you must commit yourself to socialism. We will discuss whether these socialistic objectives have been realized or not. Next, what are the other important features that we find in our constitution? The next important thing that we find in our constitution is the Directive Principles of State Policy, DPSPs. So what are these Directive Principles of State Policy? Basically, the Directive Principles of State Policy, as the name itself indicates, provide guidelines and directions for the state in formulating its public policies. Directive Principles of State Policy. They provided directions, guidelines to the government in formulating policies. They provide guidelines to the government in formulating policies. And the only thing here is that these DPSPs are not justiciable. That means you cannot go to a Supreme Court saying that the government has not implemented DPSPs, unlike fundamental rights. Unlike the fundamental rights. And when you look at these Directive Principles of State Policy, what you can see is that the Directive Principles of State Policy are nothing but what we call Gandhian principles. If you look at our constitution, the entire constitution was framed by scholars who were educated in London, Western education. They were influenced by what you call the Renaissance, Western liberal economic and political philosophies. Even though the entire freedom movement was led by Mahatma Gandhi. Obviously, there was a lot of criticism of our constitution, saying that our constitution never reflected Indian ethos, Indian values. That is when our constitutional forefathers decided that they must pay some kind of lip service to Mahatma Gandhi. That is when they included Directive Principles of State Policy. Otherwise, you don't find any Gandhian values, Gandhian principles in our constitution. These are the questions that normally UPSC asks about all the time. Because they will not ask you innocently what are fundamental rights or what are directive principles. These are the questions which will be answered by kindergarten students. What are fundamental rights, when did you study about fundamental rights or directive principles? Did you ever study at all, first of all? Yes, studied. When? 8th standard civics books. If at all, if you remember. That is the reason why, for UPSC preparation, normally what the coaching institute says is that you should start reading NCERTs from 6th standard. Why? Because when you were in 6th standard, you never studied them. Right? Otherwise, why should you study, 9th, 10th or 11th, 12th standard NCERTs now? Had you studied them at that point of time, instead of indulging in cultural activities, you would not have, had this problem of studying them now. Okay, you study about fundamental rights and directive principles at that point of time, which you should have studied, which you did not. That is the reason why we are forced to repeat them in the class also. That is the reason why UPSC will never ask these kind of things. Whether what is Article 14, 15, 16. They will never ask these things because they are part of what is called Bonvita quiz contest for children below 14 years. Okay. What they will be asking is, where do we find Gandhian ideals in our constitution? That is what they will be asking. You find all the Gandhian philosophy and Gandhian ideals in directive principles of state policy. Article 40, establishment of Gram Panchayats. Gandhi always dreamt about transforming our villages into self-sufficient independent republics. Article 44, Uniform Civil Code. Similarly, rest of the articles which talk about protecting the interests of the workers, protecting the environment. Gandhi always talked about sustainable development. All of them were made part of what you call directive principles. If you look at it, it was Ambedkar who influenced our constitution, and Ambedkar was, had more hatred for Mahatma Gandhi than the Britishers. At any point of time, Ambedkar had more hatred for Gandhi than Britishers. Obviously, when he was given the opportunity to frame the constitution, he made sure that Gandhi's name was never there in the entire constitution. Yes, it was true. It's a fact. So that is the reason why at the end of the day, when they were discussing among themselves, they realized the fact that Jawaharlal Nehru was a disciple of Mahatma Gandhi, but only for the name's sake, because Nehru's ideology, philosophy was completely different from Gandhian philosophy. We will discuss all these things. This is what they will be asking as part of your history as well as polity governance or Indian administration. Why? Because Nehruvian philosophy is completely different from Gandhian philosophy. At the end of the day, when they realized that they did not include any Gandhian ideals, then they talked about DPSPs. So this is what DPSPs. Then what else the constitution talk about? Next important thing they talk about is the local self-governments. Local self-governments. As I said, this local self-governments again was a Gandhian ideal, which was implemented almost 50 years after independence as part of 73rd and 74th amendments. So what we have to do is that we have to analyze all of them, starting with separation of powers, judicial independence, parliamentary democracy, federal form of government. We will have to see how we have been able to realize the dreams of our constitutional forefathers. Because when our constitutional forefathers had come out with the constitution, they expected the future generations. They expected the future generations to fulfill the ideals which have been mentioned in the constitution. The big question here is that whether they have fulfilled all these dreams of our constitution for the constitutional forefathers or not. Who are expected to fulfill the dreams here? Who are expected to fulfill them? Who are expected to realize the ideals of the constitution? Who are expected to realize the ideals of the constitution? Political executive. Those who come to positions of power. And how this political executive comes to positions of power? They are elected by people. So if we have to see whether our constitution, is functioning in reality, we should know how our political parties are functioning, on what basis our people are electing political parties to positions of power. This is what is called polity. The relationship between constitution and polity. Constitution is basically a written document that provides information about the relationship between the citizens and the state. But the ideals of the constitution have to be fulfilled by the political parties with the help of the people. We have to see whether this has been realized or not. 70 years of independence, 70 years of independence. I think next year we'll be celebrating after 2 years, 75 years of independence also. Our Prime Minister always remembers these kind of things. That is the reason why he said that after 75 years of independence, we have to make India completely, corruption free, pollution free, people free. Okay. Because corruption and pollution will be there only as long as people are there. Okay. So that is what he will say. We have to see whether we have realized those dreams or not. And that is what the essence of our entire syllabus. So proceeding further, how do we know whether we have realized the dreams of our constitutional forefathers or not? We will come to know on the basis of what is called constitutionalism. The most important word, the most important term in the entire syllabus of our polity governance as well as Indian administration papers is constitutionalism. Every answer you must start with constitutionalism. Every answer you should start with constitutionalism. If you are writing about President of India, you start with constitutionalism. If you are writing about a federal form of government, you start with constitutionalism. If you are writing about declining standards of our parliament, you must start with constitutionalism. So, what is this constitutionalism? Whether we have this constitutionalism in the functioning of our political and administrative systems or not. If we don't have it, what should be done? Please remember, in your prelims also, the questions were asked about these things. 2 years back, in your prelims, they asked the question, constitutionalism means, they give 4 choices. Okay. So let us try to understand all these things. What is constitutionalism? To understand about constitutionalism, we should know about the constitution first. We should know about constitution. If you have to understand about constitutionalism, we should know what is constitution. What is constitution? What do you think is constitution? Basic rule of land. What about the sky? Or the land below the land? What is constitution? First of all, before asking about the question what is constitution, why should we have a constitution? Why constitution? I am asking why should there be any constitution at all in the first place? Then we will discuss what is constitution. Why should we have a constitution? Why should we have a constitution in the first place? Take the case of United Kingdom. It has no constitution, but it has a rule of law better than India. Take the case of Pakistan. It has constitution. You should know also. You must believe also. Pakistan also has constitution, or for that matter, even Afghanistan also has constitution. What is the name of Afghanistan constitution? That is what they will be asking you in your prelims also. In your prelims, this is the kind of question they will be asking. Be careful. So, why should we have a constitution at all? Why should we have a constitution at all? For a country like India, why should we have a constitution at all? Why should we have a written constitution? You are talking about what is constitution? Constitution means codification of laws. Why? Why should we have a constitution? To provide guarantees. This is where we take the help of political philosophers. We have a philosopher called Thomas Hobbes, a political philosopher from United Kingdom. Thomas Hobbes. What did he say? Thomas Hobbes, he said that if people are given complete freedom, it can result in anarchy. It can result in anarchy. A-N-A-R-C-H-Y. In order to protect the lives and freedoms of citizens, it can result in anarchy. A-N-A-R-C-H-Y. In order to protect the lives and freedoms of citizens, they have created a state. In order to protect the lives and freedoms of citizens, they have created state. S-T-A-T-A. They have created state. They have transferred powers to the state. They have transferred powers to the state. That is, there is an upward delegation of power. There is an upward delegation of power from people to the state. The state has been given the responsibility to protect the freedoms and rights of citizens, and also to maximize their welfare. The constitution of a country defines the powers, responsibilities and functions of the state. It also defines the relationship between the citizens and the state. The citizens and the state. So that is the reason why we say a constitution is required. Why a constitution is required? Left to ourselves, imagine there is no rule of law. Imagine there is no state. Imagine there is no constitution. And what is the only consequence? It results in complete anarchy. Jungle Raj, otherwise called Uttar Pradesh, right? Or you can add Bihar, If you want, you can add Punjab also, It is up to you. I am not saying anything here. Okay, that is what we say. Why? Because what happens, that is what economic survey also talks about. Matsya Nyaya. That means, a big fish eating the small fish. You need, you must protect the lives of the people. You must ensure safety and security. You must maximize welfare. That is what Thomas Hobbes, he said that the societies always move towards only anarchy. They move towards what is called entropy. They move towards entropy. You have to prevent this entropy. You have to prevent this destruction. How to prevent this destruction, entropy? Only by ensuring rule of law. That means every person must abide by rule of law. You must regulate the negative behavior of the people. So that is the reason why what Thomas Hobbes has said is that the citizens had come together. They had come together and they created what is called the state or the government. In a voluntary manner, they had created the state or government. And they have transferred powers. That is what is called upward delegation of power from citizens to the state. They have transferred powers to the state to perform the most important function, that is protecting their lives and rights, to maximize their welfare. How can the state perform these functions? State can perform these functions on the basis of certain written laws, rules and regulations, which we call them as constitution. Which we call them as constitution. Why this constitution is required? The constitution is needed to prevent negative entropy, to prevent entropy, to prevent anarchy, to prevent disintegration, and to protect the lives of the people. That is the reason why constitution is required. The next question that we are asking is, what is constitution? What is constitution? We have seen why it is required. Next question is, what is constitution? In simple terms, write down, in simple terms, a constitution is a written legal document A constitution is a written legal document that defines the relationship between the citizens and the state. The citizens and the state. But according to Jawaharlal Nehru, Constitution is not a static rule book. Constitution is not a static, STATIC, RULA, rule book. It reflects It reflects the soul of the country. The soul of a nation. The soul of a nation. It reflects the wishes. It reflects the wishes, demands, DMANDS. It reflects the wishes, demands, desires, DESIRES, and aspirations. And aspirations of citizens. It is a dynamic living organism. It is a dynamic living organism. This is what Jawaharlal Nehru has said. Otherwise, what is Constitution? In simple terms, it is a written legal document. What Nehru has said is that Constitution is not a mere static rule book. It is much more than that. A Constitution defines the soul of the nation. It defines the wishes, aspirations, needs, demands of its people. It is a dynamic living organism, not a mere statute book, static rule book. That is what Jawaharlal Nehru has said. Next, this is what we say Constitution. Basically, it defines what we are expecting from our rulers. It defines our needs, our aspirations, our demands, our wishes. Everything is reflected in our Constitution. That is the reason why, if you look at the Constitution of our country, it starts with the preamble, and the preamble starts with "We, the people of India," sometimes Italy also. Okay, we the people of India. That is what? That means the Constitution is the one which we have framed for ourselves. Wherein we said that this is what we are expecting from the Constitution. It is not about only the written argument, written declaration between the citizens and the state. It is much more than a static rule book. It defines the soul of a country. It defines the aspirations, needs, demands, everything about what the people are expecting from their country. So this is what we say Constitution. Now, what is this constitutionalism then? What is constitutionalism? Let us look at constitutionalism. As I said, our entire syllabus can be explained with the help of this word constitutionalism. Constitutionalism focuses on implementation of ideals of Constitution. Implementation of ideals of Constitution. Implementation of ideals of Constitution in both letter and spirit. In both letter and spirit. In both letter and spirit. As Ambedkar rightly pointed out, as Dr. B.R. Ambedkar rightly pointed out, when the constitution of a country fails, FAILS, the blame should not be on the shoulders of, when the constitution of a country fails, the blame should not be on the shoulders of, constitutional makers. It should not be on the shoulders of constitutional makers. It is the people of the country it is the people of the country along with the political parties that are ultimately responsible for realizing the ideals of the Constitution. Realizing the ideals of the Constitution. Realizing ideals of the Constitution. So this is what we say, as you have written, constitutionalism basically focuses on the most important aspect, that is whether we have been able to realize the ideals which are mentioned in the Constitution in both the letter as well as in spirit. Why this becomes important? Because as Ambedkar has said, if tomorrow the Constitution of our country fails, he was a very intelligent person. He knew that it would be a failure. That is the reason why he said that please don't blame me or my friends who are responsible for framing the Constitution. Why? Because the success of Constitution depends on one, political parties, and second one, people. Please remember why we are quoting so many of them here in your every answer, where it is polity governance or Indian administration or ethics paper, you are quoting only these people: Mahatma Gandhi, Ambedkar, Jawaharlal Nehru, not Rahul Gandhi. Okay. Of course, Rahul Gandhi is undoubtedly India's greatest philosopher. We cannot deny the fact. When he said that poverty is nothing but a state of mind, nobody could make these kind of highly intellectual statements. And he said that poor people in our country require the velocity of Mars to come out of poverty. Again, we are not able to understand what is this velocity of Mars. You are tempted to quote Rahul Gandhi, but you have to restrain yourself. If you are quoting, you are only quoting either Ambedkar or Nehru or Mahatma Gandhi. I would expect you to quote Ambedkar and Gandhi, not Nehru. Why? Because the present government, they are against Nehru. Our Prime Minister takes a lot of, pleasure in criticizing Nehru on the floor of the House all the time. So you quote Gandhi and Ambedkar. These two people are highly, respected and most importantly, non-controversial. And Ambedkar being the chairman of the drafting committee, you can always quote him without, worrying about negative consequences. So what he said is that if you want your constitution to be implemented in both letter and spirit, what is required is, you need an effective, democratic polity, wherein the political parties as well as the people, ensure, effective functioning of the constitution. How to do that? That is what again we will be discussing in an entire syllabus. That is the reason why we will talk about the political parties, how the political parties have evolved in India over a period of time, what kind of contradictions we can see, paradoxes we see in the functioning of political parties, and what kind of reforms that should be implemented to make the functioning of our political parties more accountable. All those things we shall be discussing as part of electoral reforms and everything else. Next, write down. Constitutionalism can be defined. Constitutionalism can be defined from different dimensions. Again, as I said, all these dimensions you should be quoting in your answers. What are the different dimensions of constitution? First, what is this constitutionalism? Did I say constitution or constitutionalism? Constitutionalism only. Okay, fine. I just wanted to see whether you are sleeping or not. And I can see already some of you have practiced the art of sleeping with open eyes. Some of you are sleeping. I don't have to tell you who are. They know them far better. So, what is this constitutionalism? First, Constitutionalism implies 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 strict implementation of rule of law. Strict implementation of rule of law in both letter and spirit. Strict implementation of rule of law in both letter and spirit. In both letter and spirit. Second dimension of constitutionalism. Protection of fundamental rights of citizens. Protection of fundamental rights of citizens from exploitation by protection of fundamental rights of citizens from exploitation by organs of state and private individuals, private citizens and private citizens. Next dimension of constitutionalism. It also emphasizes on constitutionalism also emphasizes on limited government, LIMITED, limited government. Power corrupts, continue with the same point, power corrupts, POWER, power corrupts, and absolute power corrupts absolutely. Power corrupts and absolute power corrupts and absolute power corrupts absolutely. POWER, power corrupts and absolute power corrupts absolutely. Constitutionalism focuses on limiting the powers of organs of state, limiting powers of organs of state, limiting powers of organs of state, so that they do not become dictators. They do not become dictators. Next dimension of constitutionalism. Next dimension. It also emphasizes on ensuring inherent checks and balances. Ensuring, ENSURING, ensuring inherent checks and balances within the system. Within the system. That is, executive must be controlled by legislature. Executive must be controlled by legislature. Judiciary must regulate. Judiciary must regulate the activities of both legislature and executive. Both legislature and executive, and so on. So this is what we say constitutionalism is all about. What we are saying is that this constitutionalism focuses on one thing: strict implementation of rule of law. That is what is called constitutional law in both letter and spirit. The rule of law should be implemented in both letter and spirit. What is the essence of rule of law? You talk about equality before law, equal protection of laws, separation of powers. This is what constitutionalism. Is it the case that every person in our country is protected by law in the same manner or not? Is it the case that our entire governance is carried out strictly according to constitutional norms or not? That is what is called constitutionalism. Why? Because you can have a written constitution and you can talk about all these things, but at the end of the day, whether they are put into practice or not, that is what constitutionalism focuses on. And other dimensions, as you have written, for constitutionalism. Constitutionalism is all about protecting the fundamental rights of the citizens from exploitation by organs of the state. As we discussed earlier here, it is the people who have created the state, and what they have done, they have given powers to the state about delegation of power. But over a period of time, what it had become is that the state had become what he called it as a leviathan. The state had become a leviathan. That is what Thomas Hobbes has said. And what happened because of this, state has acquired so many powers unto itself that it, instead of working for the welfare of the people, those who are part of the state started exploiting the power to benefit themselves, and in the process causing harm to the fundamental rights of the citizens. That is where constitutionalism talks about. You have to limit the powers of the organs of the state. Otherwise, the organs of the state can become dictators. They can take away the fundamental rights. Now look at the present government. The only problem is that till between 2014 and 2018, the government had some kind of accountability because they did not have majority in Rajya Sabha. That is the reason why most of the bills controversial bills could not be passed in Rajya Sabha. Now that they have got majority, you can safely say that we have moved towards what is called absolute dictatorship. Because in Rajya Sabha also the government has majority. All the bills will be passed without any discussion. Yesterday, around 18 political parties, they met Rajya Sabha chairman, the vice president of the country, and requested him that please ensure that we are protecting the democratic principles of our country. Why? Because the executive using its brute majority on the floor of the house to get all the bills passed without any discussion. That is where we talk about constitutionalism. As I keep on saying, almost every answer you start with constitutionalism. Why? Because there is a tendency for these organs of the state to become powerful, as we have just said, power corrupts and absolute power corrupts absolutely. And instead of working for the welfare of the state, welfare of the people, they start working to benefit themselves. And that is where this delegated legislation becomes a very, very dangerous proposition. Through delegated legislation, the state acquires a huge amount of powers unto itself, which results in what is called dictatorship of the state. Look at the recent legislations that were passed, whether it is amendments to the NIA Act, or whether it is the amendments to prevention of what is that legislation? Prevention of POCA Act is there, wherein state had been given absolute powers. State can declare any citizen as a terrorist and can take away your freedoms. You say that Narendra Modi is good, then they will say you are a terrorist because you did not say he is great. Okay, so that is where the problem is. That is where we talk about constitutionalism. As part of constitutionalism, that's why we say that constitutionalism focuses on one thing, that is proper checks and balances within the system. It focuses on what is called a limited government. None of the organs of the state should have absolute powers. There must be inherent checks and balances. Executive should be controlled by legislature, and judiciary should be able to control the functioning of both legislature and executive. And that is where you have checks and balances within the system, so that you are able to protect the fundamental rights of the citizens. That is what we say citizens. That is what we say constitutionalism. It has all these dimensions. As we proceed with our syllabus, whether our organs of the state have ensured constitutionalism is or not, is what the syllabus, the entire essence of our syllabus. We will have to see whether legislature has ensured constitutionalism or not, judiciary has ensured constitutionalism or not, executive has ensured constitutionalism or not, president has ensured constitutionalism or not, governors have done this or not, or for that matter even the speakers and other constitutional authorities have performed according to the ideals of the constitution or not. That is what we will have to see. Next, important features of constitutionalism. Important features of constitutionalism. What are the important features of constitutionalism? When do we say that a country has a constitutionalism in the functioning of its political and administrative systems? What are the important features? First and foremost, a written constitution. A written constitution should be there. A written constitution should be there. Second, the separation of powers. There must be separation of powers, clear-cut separation of powers between the three organs of the state. There must be separation of powers between the three organs of the state. Third, independent judiciary. Independent judiciary. Fourth, judicial review. Judicial review. Fifth, federal form of government, especially for a country like India, federal form of government. Federal form of government. Sixth, civilian control over army. Civilian, CIVILIAN, control over army. Civilian control over army. Defense forces, armed forces. Armed forces. Next, another important feature of constitutionalism is civilian control over law enforcement agencies, that is police. Civilian control over law enforcement agencies. Law enforcement agencies, that is what we call police. This is what we say about constitutionalism. If all these features are present in the political and administrative systems of a country, we say that that country has constitutionalism. That is what we say in a written constitution. And when we talk about all these features, they are necessary but not sufficient. That's what we say. Take the case of some countries like Pakistan and Afghanistan. They have written constitution, but do they have constitutionalism? Obviously not. On the other hand, a country like United Kingdom, it has no written constitution, but it has constitutionalism. But a written constitution is necessary. Why? Because United Kingdom is completely a different country with completely a different history. Democracy in United Kingdom developed over a period of 800 years, not 1 or 2 years. That is the reason why they could develop the conventions. That is the reason why they did not have any written constitution. They did not have any written constitution. We have a topic called comparison of constitutions. There again we will be discussing all the things. Okay, because this year they can ask, last year they have asked about India and USA. This year they can ask about India and UK. So a written constitution is necessary but not sufficient. Then separation of powers between the three organs of the state, legislature, executive and judiciary. As I said, Pakistan has written constitution, but do they have separation of powers? Very doubtful. Why? Because they have judiciary which is neither independent nor impartial. They have a president who does not have any real powers. When Imran Khan went to America to meet the president, along with Imran Khan, the president of Pakistan, the ISI chief as well as army chief also, attended the meeting. That is what we call, banana republics, banana democracy. Okay, they don't have any real powers. That is the reason why we say that they don't have any constitutionalism. And similarly, we talk about independent judiciary, judicial review, and then civilian control over army. That is what we say. Take the case of India. All the three chiefs of army, navy, and air force, they must be working under a civilian representative, defense minister. They cannot do anything independently. Again, we will discuss all these things. Why? Because when UPA was in power, when the Congress party was in power, there was a situation wherein the army chief wanted to declare some kind of a revolt. That is when the government had become very panicky, Manmohan Singh government, and what happened there we will discuss later. Civilian control over army. Similarly, civilian control over law enforcement agencies. Law enforcement agencies means police forces. Police cannot act independently, otherwise it results in what is called police state. Police at the district level, the superintendent of police has to work under IAS officer, and all of them should be working under the Home Minister. Civilian control over law enforcement agencies. This is what we say constitutionalism. Now coming back to India again here, do we have all these features present in our constitution? Yes, we have a written constitution. Yes, and separation of powers. Yes, independent judiciary, judicial review. Yes, which article of the constitution gives the powers for our judiciary to review? I am just trying to find out. I am not only asking, just to see whether you know something about constitution, whether you have studied up to 8th standard or not. Which article? We have 440 articles. You can name anything. Right to freedom of speech and expression is part of your fundamental rights. Which article? 140, 170, 280, anything, you can name it, you have freedom. Otherwise, the correct article is Article 13, 1.3. Otherwise, you can talk about any article, you have freedom. What does Article 13 says? What does Article 13 says? It says that our Supreme Court has the power to declare any law passed by legislature what? Ultra virus, if it violates the fundamental rights of the citizens. Judicial review, it is there. It has the power to review any legislation made by our legislature for its constitutional validity in terms of violating the fundamental rights of the citizens. That is where we talk about judicial review. We will talk about all these things. As I said, don't worry, we will talk about all these things. Next, we have civilian control over army as well as, civilian control over law enforcement agencies. All these things are present in our constitution. Does it mean that we have constitutionalism? The $1 million question here is, $1 million has become very old. $5 trillion question here is, okay. Nowadays our Prime Minister, day in and day out, whether it is day, night or evening, he is only dreaming about $5 trillion. The $5 trillion question here is, do we have constitutionalism in reality also? We have constitutionalism, that is what you write. In India, constitutionalism is present in letter but not in spirit. It is present in letter but not in spirit. It is present in letter but not in spirit. In fact, what we have, right? In fact, what we have is constitutional formalism. Constitutional formalism. Formalism. That is the difference between the ideals of our constitution, and the reality, in our society. We are very far from reaching or realizing. We are very far from realizing. We are very far from realizing the ideals of our constitution. The ideals of our constitution. So, when we are making these kind of radical statements, we should always support these kind of statements with facts. Why do we say that we do not have constitutionalism in the functioning of our political and administrative systems? Why do we say that there is huge amount of difference between what is there in the constitution and what is there in reality? We have to give some examples. We will give those examples. There are so many examples, but we will give few examples to explain why we don't have constitutionalism. First example is 40% of our members of Lok Sabha, 40% of our members of Lok Sabha have criminal records against them. Have criminal records against them. 40% of our members of Lok Sabha have criminal records against them. Lawbreakers have become lawmakers. Lawbreakers have become lawmakers. When lawbreakers become lawmakers, can there be any rule of law? That is what you write. When lawbreakers become lawmakers, rule of law becomes a major casualty. Rule of law becomes major casualty. CASUALITY. There will not be any rule of law when lawbreakers become lawmakers. So can we say that we have constitutionalism? Is there any rule of law? No. What does rule of law says that? It says that you should punish all those who break the law. Otherwise what is the use of rule of law? The essence of rule of law, as we keep on saying, is that to protect the good people and punish bad people, those who violate the law. And we are punishing bad people. How? By making them lawmakers. That is what, in the present Lok Sabha, 40% of them have criminal records against them. Criminal records, not petty crimes like theft and all these kind of things. It is not like cutting the purses in metro trains. That is very petty thief. These people are very highly experienced, knowledgeable, highly skilled criminals. That is the reason why they commit much bigger crimes like murders, dacoities, kidnappings, and other cultural activities. All of them. Recently, only one BSP MP, I think, he was arrested for rape, who got himself elected to Lok Sabha recently on rape charges. And then you have people like Azam Khan, who are respectable members of our parliament. Okay. When lawbreakers become lawmakers, there will not be any rule of law. There will not be any constitutionalism. In any other country in the world, all these people should be spending their time peacefully behind the bars. And what are they now? They are spending their time peacefully in Parliament. That is one of the reasons why India has become what is called a soft state. A soft state means a state which cannot take tough decisions, implement tough decisions. Why? Because when the lawbreakers become lawmakers, will they come out with any tough legislations to punish themselves? No. That is the reason why, India we always say is a banana republic. Why? Because, you take the case of Prevention of Corruption Act 1988. It is not applicable to MPs, MLAs and other people who are in public life. And all of them are corrupt. And they don't want to come out with any legislation that make them guilty of corruption. And that is the reason why Lokpal, is yet to function. It is yet to function, Lokpal. That is where the problem is. That is the reason why we say that we have this constitutionalism only in letter but not in spirit. The second reason why we say that we don't have constitutionalism, and the reason, in the Global Transparency Index, India is more corrupt than its neighbors also. Corrupt people are never punished. Honest people are not protected. That is the reason why we say that there is no constitutionalism. In the Global Transparency Index, our position is coming down every year. All our neighbors are more honest than us. They don't have any democracy. Take the case of Pakistan. They don't have any democracy. They don't have any written constitution, everything else. But still, it is more honest than India, which has a written constitution, robust judiciary, independent press and everything else. In spite of the fact that we have all those things, these structures are there only for namesake. In reality, corrupt people are never punished. When was the last time the government has recovered money from the corrupt politicians or bureaucrats or businessmen? When was the last time? Can the government recover a single rupee from a Vijay Malaya or for that matter Nirav Modi? That is the reason why corruption has become a low risk, high gain activity in India. Why? Because there is no rule of law. Because there is no constitutionalism. Next reason why we say that there is no constitutionalism in our country. Another reason. People are not able to enjoy fundamental rights. We don't enjoy fundamental rights, which are guaranteed under Constitution. Is it the case that all citizens of our country are enjoying fundamental rights which are guaranteed under Constitution? No. You want to eat something, someone will come and start eating you. You want to practice some religion, someone will else come and say that you have to say Jai Shri Ram, otherwise you will be killed, you will be sent to Ram. That is where increasing intolerance, communalism, caste conflicts, religious discrimination, discrimination on the basis of language. We talk about as part of our fundamental rights, right to public employment. You can go anywhere in the country and work anywhere else in the country. But in reality, is it there? You are from Bihar and you want to go and work in Bombay. And then suddenly near the railway station, Raj Thackeray will be there, welcoming you with open arms. So that once you come there, he will kill you and there will be garland over your dead body. welcome to Mumbai. That is what recently, Andhra Pradesh state government had passed a legislation saying that 75% of the jobs should be given to locals, which is blatantly against constitution. You cannot discriminate on the basis of locality, religion, but that is what we do all the time. Do we have constitutionalism? Obviously not. Next reason why we say we don't have constitutionalism. More than 45 million cases. More than 45 million cases are pending with our judiciary. More than 45 million cases are pending with our judiciary. And it is said that it would take our judiciary at least 300 years. At least 300 years to come out with the judgments in these cases. It would take our judiciary at least 300 years to come out with judgments in these cases. Justice delayed is justice denied. Justice delayed is justice denied. That is where we say we don't have constitutionalism. Again, all these things, as I said, we will be discussing separately. So at the end of the day, what we are saying here is that in India, we have only constitutionalism in letter but not in spirit. So entire constitutionalism debate is about how to transform our representative democracy into participative democracy. How to move from bureaucracy-centric administration to citizen-centric governance. Ultimately, how to empower citizens. How to ensure empowerment of citizens. That is what we say. And who has to ensure this constitutionalism? As we have discussed earlier, as Ambedkar pointed out, it is the political parties and the people who are ultimately responsible for constitutionalism. When can political parties ensure accountability? When can they reduce corruption? When can they eliminate discrimination? When can they protect the fundamental rights? Only when people are willing to vote in elections on the basis of the performance of political parties. Only when people are aware about their rights. Thus, the success of any democratic polity depends on awareness among the citizens. The question was asked so many times in our polity governance as well as Indian administration papers. The entire constitution success depends on awareness among the citizens about their rights. Unfortunately, in a country like India, since the people are poor, backward and illiterate, they cannot make their governments accountable. There is no what is called democratic functioning of our political system, which is the most important reason why we cannot ensure constitutionalism. So how to ensure that? That is what I think we will be discussing on Monday. What can be done to ensure constitutionalism? We will be discussing on Monday. We will look at the political parties, the functioning of the political parties, the kind of attitudes that we have among the citizens, the kind of political culture that we have, so that we can ensure constitutionalism. So tomorrow you don't have any class, and on Monday, we will continue with all these things. As and where it is required, I will dictate the things. Otherwise, we will discuss important things also. When dictation is not required, we will discuss. Otherwise, I will dictate everything. Right? We will meet day after tomorrow at the same time, and make sure that you are here before 8 o'clock. That is what is called constitutionalism. You are here before 8 o'clock. Right? So we are meeting day after tomorrow at the same time. Yeah. Same 9 o'clock. 9. I think you have got the message also, I think.